CV 020460 Tricon SFR borrower, Mr. Michael Bernard Hill. The gentleman not being present, waiting on this to open. It's now 9:10. The matter was duly set for trial at 9 o'clock today. Given the gentleman's failure to appear, how do you wish to proceed?
In absence of the defendant, Your Honor, we would ask that the appeal be dismissed, the magistrate's judgment be reinstated, and the rent bonds be released to the plaintiff.
All right, we're going to class. Ms. Hill, the next one being 25 CE 020529 CHMF Charlotte Research 3 Alexis Boyd. Is Alexis Boyd present? All right, counsel, the matter having been duly set for trial today at 9 o'clock. It is now 9:10. The defendant has failed to appear. How do you wish to proceed?
We would just ask that the appeal be dismissed, the magistrate's judgment be reinstated, and the rent bonds be released to the plaintiff, Your Honor.
I will grant your request. I'm just marking times and things in here. All right, the next one being 25 CE 019922 AGECP Bellhaven Owner LP Brittany Johnson. Ms. Johnson? All right, counsel, this matter having been duly set and noticed for trial today at 9 o'clock, the matter failing to appear, how do you wish to proceed?
We would just ask that the appeal be dismissed, the magistrate's judgment be reinstated, and the rent bonds be released to the plaintiff, Your Honor.
All right, you grant your request. Excuse me. Let's see, and the last one that I have on the docket would be 25 CD 021195 Eco Coil Hollow LLC Sabrina Coley, C-O-L-E-Y. Ms. Coley? All right. The matter having been set and noticed for trial today for 9 o'clock, it's 9:12. The matter has failed to timely appear. Counsel, how do you wish to proceed?
We would just ask that the appeal be dismissed, the magistrate's judgment be reinstated, and the rent bonds be released to the plaintiff.
Okay. That leaves remaining on the docket the two matters with the individuals that are currently here. Do you want to go ahead? Did I miss it? Okay. Do you all want to go ahead and speak with those individuals?
I'll speak with
them.
them.
The record for a little bit?
Yes, Your Honor.
Okay.
For anyone here, process with it, I've never been through this before, and I have keys at the house, right? I got 5 keys at the house.
Yeah, that's why I said, if you ask me a question, I'll answer your question, but if you interrupt me, I can't give you information. Okay? I cannot give you legal advice. I can't tell you what the next steps are. That's why you should go down to that self-help center down on the 3rd floor. That's for the public. They can answer the questions for you.
Yes, ma'am, I appreciate it.
Thank you very much. All right. Give me a second. I'm in another case. Let me back out of this and I'll call them. This is it Malika?
Yes, ma'am.
Okay. All right, Ms. Nels. Thank you. 25 CV 021304 BRC Charlotte 485 LLC. Ms. Malika Hill, the matter is present. Ma'am, do you have a lawyer? You just have to answer out loud. So I asked this question of everyone. Pull that microphone just down a little bit to you. You are soft-spoken. I've got a wonky ear, so. All right, so the matter is appearing representing herself, the gentleman, Mr. Brown, is present with his client, representing the plaintiff. We are here, madam, because you filed a notice of appeal of the magistrate's order. We're here for what's called a trial de novo, meaning Mr. Graham and his client have to prove their case from the beginning again. Whatever happened in the magistrate's court, I don't consider. Whatever you all talk about in private, I don't consider that either, okay?
Okay.
What I'm going to do is pull up some documents and look at some procedural history.
Okay.
And then I will hear from the gentleman, Mr. Graham, first, and then I will hear from you, okay?
Okay.
All right, give me just a second to take a look at a couple things.
And I do have a pretrial motion, Your
All
Honor.
right, give me just a sec, we'll go through that. All right, I see the complaint being filed. Are we here on possession, money judgment?
Possession only, Your Honor.
All right, so ma'am, what that means is I'm only going to be asked to make a decision on one issue, on the physical structure. Although you may hear about money being owed, I am not being asked to enter a money judgment today, okay? All right. So I see the judgment from the magistrate having been entered on 5/14/25. The amount of filed term notice of appeal. Notice of appeal being filed on 5/19/25. Deputy, is the gentleman looking for me?
I'm sorry, no.
Is the gentleman looking for me? All right. And what the other thing I will tell you, ma'am, is if you have paid any rent bond, I'll get the official court documents, okay?
Okay.
All right. Counsel, tell me your pre-trial motion.
We would just make a pretrial motion to dismiss for lack of subject matter jurisdiction due to the deficiency of service on the notice of appeal, Your Honor.
All right, let me pull the document and then you can tell me about it.
Absolutely.
All right. So ma'am, what I'm being asked to consider before we get started, one of the things that I have to have is jurisdiction to hear the case in the first place. If I don't have what's called subject matter jurisdiction, I can't even hear the first word from either of y'all. So the gentleman is asking me to consider dismissing your appeal because I don't have jurisdiction, and I'm going to hear from him on that, and then I'll get some information as well. All right, I have the notice pulled up. What do you want to tell me, counsel?
And so, Your Honor, under 7A228, it dictates how the appeal shall be filed, the course of action to maintain the appeal properly, and how they can establish the court's jurisdiction. And in order to do that, they have to serve that notice of appeal in accordance with Rule 5, 1A1, Rule 5. And that requires that service shall be made on the party's attorney of record. In this matter, we were never served with the notice of appeal, Your Honor. And if you look at the certificate of service side, it has that it was served on the defendant, the plaintiff's attorney. Doesn't state how it was left with the plaintiff's attorney or how it was delivered to the defendant or plaintiff. And then it also states that the name and address of the person to whom it was delivered to was the defendant's name, Your Honor. And so, based on all those facts, we would ask the court to dismiss this for lack of subject matter jurisdiction for not properly serving this notice of appeal.
Okay. So ma'am, essentially what I'm being asked to make a decision on is whether or not the notice for the appeal was properly given to the lawyer for the apartment community such that I have jurisdiction. And there's a rule that says there are these steps that you have to do. Gentleman is saying if you didn't follow those steps, don't go far. Are you kidding me? Oh, okay. The gentleman is saying that you didn't follow those steps and that I should dismiss for lack of subject matter jurisdiction. So I've got the notice of appeal pulled up. I can see the deficiencies that the gentleman is talking about, how you filled out the second page and whether or not it was sent to the lawyer. So I will ask you, madam, did you send a copy of this notice of appeal front and back to the law firm representing the...
I sent it to, I was advised to send it to, or give it to the property. So that's what I did. When I went to the third floor and I filled out the paperwork, I asked them how am I to give it to them, and I emailed a copy over to them.
Okay.
So they have a copy, or they had a copy of the new court date. I sent it the first time, and I'm not sure if they got it or not. She didn't
I don't mean important. I mean this notice of appeal.
Yes, ma'am. When I came, I pulled up because I had a new file, and it showed the new court date as well with my appeal. I sent it in an email.
Okay, but did you ever send it to a lawyer?
I wasn't advised that I had to send it to the lawyer. When I asked on the third floor, how do I give it to them or who do I give it to? That's all that I did. I did what I was told.
When you say the third floor, are you talking about the clerk's office at the window?
Yes,
or the
ma'am.
people in the self-help center?
At the window.
Okay, okay. Anything else that you want to tell me about how you delivered the notice of appeal or filled out the back of the form?
When I filled out the form, I asked if there was anything, this is my first time ever going through this, so I'm not sure of the steps, so I'm learning as I go. If they're not telling me that anything is wrong with the paperwork, how am I to know? I don't know.
All right. Anything else that you know?
No, Your Honor.
All right, so there are certain rules that I have no choice but to abide by, whether I like them or not, and sometimes they can be harsh. I have no choice but to hold you to the same standard that I do because you're representing yourself, the same standard that I do for a lawyer.
I tried to get a representative, but it's the notice and it's through my job, so.
And I can appreciate both the fear and the frustration. But I don't have jurisdiction based on what you're telling me, which is why I ask some of the questions that I do, right?
How am I supposed to know that they unable to provide the information that I'm providing to them, to their lawyer?
So what I can tell you.
How am I supposed?
Hold on. I have no choice but to dismiss the appeal for lack of subject matter jurisdiction. What I can tell you is that unfortunately the clerks are not lawyers.
So how was I supposed to know that the paperwork was not filled out correctly? If they're the person that I go to for the appeal, and they're the ones that's entering the information for the appeal.
So what I will tell you the same thing that I told the other gentleman. The self-help center is the place that gives the correct information, not the clerk's office. I have no choice but to dismiss it.
So what does that mean for me?
So it means that I don't have jurisdiction to go beyond this step, right? When I lack subject matter jurisdiction, it means I'm not even allowed to hear everybody's names when it comes to the case. It means that your appeal is dismissed and the order that was entered by the magistrate is put back into effect. Beyond that, I'm not allowed to give you any legal advice. And I would tell you, just like I told the other gentleman, go down to the third floor of the self-help center. That's the place to get the answers to your question. They have binders and books on instructions on how to do this whole process. And that's the only information that I'm permitted by my rules that govern judges that I can. I'm not allowed to go beyond.
So now that I've heard your ruling, what does that mean?
So it means that your appeal is dismissed.
Okay.
And then the order I saw the date on the order, but I'm looking at the notice of the appeal. Whatever the decision of the magistrate was, comes into effect.
Okay.
Okay? Beyond that, you can either have a conversation with the gentleman, they don't have to talk to you at this point, if they don't want to, I can't meet them. Or you can go down to the third floor of the self-help center and ask them again.
Thank you.
All right.
Thank you, Your Honor.
I can, if you need mental work, I can do that.
Yes, please.
That's the only other thing I can do. I just need your driver's license so I get the meeting, or not, whatever you want. I can do that. All right. They're not talking. No, they're also, when I try to pull up a website for a law firm, I get this, but I am able to see North Carolina for appeals website. But I've sent a document to the time, and it says it's printing, and it goes through the process, and then nothing shows up. Yeah.
The other matters, it's settled, I just gotta get signatures.
Okay, and as soon as Madam Clerk has that info for me, I'll sign. They're PDFs, but it's on the pages. They're little. Oh, thank you so much. Oh, careful on that. Thank you. Yes, I see that. Thank you very much. Good luck to you. Breaks my heart. I'm sure you can help me to It's not fair. But I'm happy with my small. No, it's open like this. You know, the mouse right there. But then it's my operating fingers hurt. Yeah, so now it hurt my knee. So Deputy, we're not gonna have anything else this morning. That was it for our live stuff until we come back are we coming back at 1:30 or 2 o'clock? 1:30. 1:30, yeah. Good afternoon, everyone. Come on in, have a seat. Give me just a second, and we'll go on record. We will triage the case, see where we're at. Yes, sir. Alright, 23 CD 033411 CUSA NC Holdings LP DBA Camden Newdow Apartments versus Tyrus McDaniel, aka Tyrus City Acute McDaniel. Let's go ahead and have everyone put their appearance on the record.
Good afternoon, Your Honor. Patrick Johnson on behalf of the plaintiff.
Morgan Reese on behalf of the plaintiff.
Very good. And now you go ahead and put yourself on the record.
Dr. Tigris Sidney Acute McDaniel,
Very good.
JD.
So this case has a bit of time set aside. We've got some pretrial motions that need to be dealt with. Let's find out where we stand as far as pretrial motions from the plaintiff.
Well, we can't find out from the plaintiff because we have a jurisdictional issue. I have already continued. You are disqualified wholly from any.
I will hear what your motions are. It's plaintiff's complaint. I always start plaintiff and defendant. I know that you have pretrial motions and that one of them is a jurisdictional issue, and I will hear you on that.
It is not just that. We have.
Ms. McDaniel, In order for us to move methodically through what's pending, whether you agree with it or not, I'm going to hear you on that, but I need to be able to manage the time in the courtroom accordingly, which means that I have a method, and I need to not be interrupted. You will get your chance to be heard, not a problem. But there's a method that I need to go to know what's on the table. I have a file in front of me, but I can't continue to be interrupted. And I need to know that you'll be all right with that and that you will abide with that.
I am not interrupting you as a Juris Doctorate, and you formally as a licensed attorney prior to being on the bench, you know that you are absolutely without jurisdictional authority to hear anything in this case. So you cannot set a trial date. You cannot hear any pretrial motions. You cannot assume the bench as you're doing right now. You are usurpadly presiding over this hearing. I have absolutely no gripe whatsoever, and this has been reiterated over and over and over to the court. I am not the delay in this case. The delay is on the other side, but you presiding over this action is not proper. There's no jurisdictional authority that you have at this juncture.
I understand that is something that you're challenging. Again, I'm going to take it. Your pending motions, sir, as they sit now, pre-trial, before we deal with the substance elements.
Your Honor, the only motions that the plaintiff has pending is a motion for sanctions and a motion to dismiss appeals.
Okay.
There was a motion to quash a subpoena, but there's been nothing.
But the motion to dismiss the appeal is not counted for today.
Neither is it valid.
Ma'am, I'm going to say it, please. You're going to want the record. If there are multiple voices, it will come as inaudible, and it makes for a transcript to be very difficult.
You are not
getting to have one voice at a time. The gentleman is answering the question of the court. Give it a minute, and I will get to you. Just stop. I'm asking you to stop.
So you're not going to allow me to make objections? You're not going to allow me to, is that what you're saying?
I haven't even gotten there. I just want to know what's on the table. What's on the table?
The plaintiff's motion for sanctions, plaintiff's motion to dismiss appeals. It's my understanding that all pretrial matters were scheduled for hearing at the trial of this matter pursuant to Judge Wiggins, I believe it was January 16th, 2025.
And I have that, but I don't recall a motion to dismiss the appeal being part of that.
It is not.
The motion for sanctions, I'm aware of. That will be post-trial. I don't recall the motion to dismiss appeal being addressed by Judge Wiggins' order. And what was the third one?
There was no third.
That was it.
Oh, you said there was a motion to quash.
Well, it was a subpoena that she had issued in the context of this case. She hasn't done anything to schedule a notice any hearing on that. So.
And I'm not doing a motion to quash now. I do not have a motion to dismiss the appeal as part of Judge Wiggins' work.
That's fine.
It says defendant's Rule 60 motion regarding the order of recusal on the magistrate, defendant's motion for sanctions, plaintiff's complaint and summary judgment, defendant's counterclaims, plaintiff's motion for sanctions. So as far as motions are concerned for y'all, it is strictly the motions for sanctions other than the complaint.
Correct.
And we'll hear that post. I'm not doing that as a pre-trial motion. And Madam, what I have for you pending, and you tell me if there are additions, is your Rule 60 motion on the order entered on the recusal of the magistrate, your motion for sanctions against the plaintiff, and your motion to dismiss for lack of subject matter jurisdiction.
I have no, that's not it. I have additional motions that are before the court, and again, that's the primary reason why, again, you have completely jumped the gun in this arena, and it's actually quite egregious at this point, because again, I am not the delay in this matter. Judge Wiggins, just like in my other cases, because Judge Wiggins now is the chief district court judge, and he has become aware of the fraudulent nature of the gatekeeper order, and that has been discussed severally by Judge Wiggins in several of my pending actions. Just to allude to this very quickly before going into the other motions that are pending, before, number one, Judge Wiggins, because as Chief District Court Judge, he is the one that has the quasi-judicial authority to review my filings under the fraudulent gatekeeper order for filing in this action as it relates to the district division that you unlawfully transferred it to, because it is not lawfully before the district court in direct violation of Local Rule 1016, which is pretty straightforward. It's very plain. It's one paragraph. In fact, it's one sentence. And those of us with a Juris Doctorate can very easily understand the plain language of that rule. Judge Wiggins evidently is handling a myriad of matters, not only as it relates to now having to assume this quasi-judicial scope of this pre-filing review, which he has noted on court record is absurd in one regard, but has asked that I give him the opportunity to address it directly and give him the opportunity, ironically enough, with you saying the same thing, that there's a method to it and a procedure, and he is aware of the fraudulent nature of the gatekeeper order. And with that being said, there are several motions that I have submitted directly to the judge's chambers in direct accordance with his direction to continue to use the procedures that forcibly retired Trosh had stipulated outside of the gatekeeper order. So they're not stipulated in the gatekeeper order. It was an email that I received from Marian Osorio at the direction of Trosh that, of course, myself and Judge Wiggins are aware of. And so he asked that I continue to use that method until they get this gatekeeper order resolved, because at the end of the day, the Superior Court judge, Judge Archie, who has been unlawfully ignoring all of my submissions. I've submitted everything in accordance with Trosh's instructions that, again, do not appear in the gatekeeper order, because the gatekeeper order itself is devoid of very specific instructions. And you're even aware of this because this came up in the DVPO case as it relates to Jamil Mays when you were in the hearing on February 25th, 2025. So those motions are before him to approve or deny. And quite frankly, all of my motions, all of my pleadings have been approved for filing because they're all legitimate. I don't have any history of frivolous filings. In complete opposite of...
Tell me, original ones that I listed, what
Yes,
this matter?
I can. So
This matter.
Yes, I know, for this matter. So number one, there's a renewed motion for your recusal because it expands to this entire, and whether you read it or not, that motion actually was filed. But evidently there's been no secondary order or no subsequent order from Judge Wiggins actually adding it to this calendar because he wasn't aware that you were going to schedule this calendar. This was not to be scheduled for trial.
Instead of arguing the motion, what's the title of the next one?
No, we're not done with the first one that I just mentioned. So that one,
Motion for
it's not only for your recusal, but for this jurisdiction. And it's also including a motion for change, a renewed motion for change of venue, because of all the scope of the fact that I am a politician here. I am at least 10 judges have either, they are subject to recusal due to our direct relationship on the campaign trail. You are subject to recusal for our indirect relationship on the trial, relationship in politics and your subsequent actions, which has also been reasserted through my amended renewed motion for your recusal, which included Judge McCallum, and Judge McCallum has recused herself, and she specified because it does definitely affect the partiality or impartiality in this case. So again, I'm not arguing the matter. I'm just giving, when you're wondering about titles, it's also important that you understand the scope of it, because again, it is altogether unclear why you're proceeding in this matter. I want this matter between us. I would like it resolved as well, but this is not the way. We can't do it unlawfully. Okay. So then the second motion that is still before the court, because I have appealed your initial motion, your initial denial of my motion to recuse you, and that is still in the briefing stage, and that is valid. And because it affects, clearly right now, it affects a substantial right, which is my due process rights, you all can't proceed on trial. Number two, I have renewed my motion, or excuse me, renewed my demand for a jury trial, because it's very clear that you have ignored that altogether, because you scheduled a bench trial. And that is inviolate. You can't set a bench trial for a jury trial request. So this is ridiculous. Then thirdly, there is a motion for, I've already talked about the motion for change of venue, the motion for sanctions for them, which is valid. Their motion for sanctions is not valid. And then there is, because I brought it with me today, there's a motion for sanctions against Nathan Wilson as well. And then my response in opposition to plaintiff's July 2nd, 2025 brief and memorandum. And those are admittedly so the reason why I'm taking pause is the only reason why these would rise to the level of pretrial matters is because of the fact that I have not had the opportunity to actually have these filed in the case. So whatever has been argued by Nathan Wilson on behalf of the plaintiffs effectually has the legal effect of being unrebutted. And so that's what I raised in my notice of appeal from your order denying my motion to continue. And again, I have now appealed that, and that is filed. The clerks admitted, and I'm not sure if you've spoken to Marquisia Hatcher or Madam Clerk, but at this juncture, they did not want to continue violating my rights, and they flatly told me that they filed my notice of appeal, even with there being the possibility of them being held accountable for doing something inappropriate. And I agreed with that completely because it was proper. And then fourth, quadrice here. Oh, that's the one that's fourth. So again, whereas it may not immediately appear to be a pretrial issue in this, or pretrial motion in this particular case, it has to do with my motion for relief in Wake County, because there is a preceding action, my complaint against the now plaintiff, because they were defendants, which also includes American National, Casual, and Property Insurance, because this is a matter that has to do with unfit premises, specific performance, negligence, breach of contract, breach of quiet enjoyment, and we cannot proceed upon a trial in this matter without having all parties of interest in this action. And my case preceded their retaliatory summary ejectment case, and that hearing was held on my motion for relief because the laws restrict transferring a case to a county where there is an active gatekeeper order. And Judge Eagles still has that matter under advisement, which I have severally raised that point that this action cannot proceed in that regard. And so ancillary to that, which is not just, it is not inferior with regards to importance, is my motion to add or for joinder of American National, which was effectually resolved in Wake County because they were added, but again, it carries over to this action because they have not been added in this case.
All right. So I want to make sure that I have all of what you described so that we can move through each one of them. So give me just a moment. I'm looking at my notes and typing them out. What I hear from you is that you have your renewed motion for my recusal, your motion for sanctions, your Rule 60 motion for relief from the recusal of the magistrate, your renewed motion for change of venue, your renewed demand for jury trial, and the motion to dismiss for lack of subject matter jurisdiction. Do I have all of them?
I feel like there's one that I mentioned to you, and you actually noted because it's tiered. It's a combined motion. The subject matter jurisdiction and motion. Did you say motion for joinder?
No, I do not have a motion for joinder.
Yes, that's what I'm saying. But they have it.
I don't have it in my notes because I didn't hear you mention it.
No, motion for joinder. Yes. What for?
So which of those motions did you submit for Judge Wiggins' review?
I have submitted them all.
Well, some of them were approved by him because I have his order.
Right.
Right?
Yep.
The motion to dismiss for subject matter jurisdiction is set, so that one is fine. But I'm wondering, so I think it's the renewed motion for recusal. The sanctions was approved, the Rule 60 was approved. The renewed motion for change of venue, renewed demand for jury trial, and the motion for joinder.
Correct.
Therefore, what date were they submitted for Judge Wiggins' approval?
If you'll give me 1 second, I'll need to look in, because I very routinely, because of the nature of my pleadings, and I'm trying not to hold Judge Wiggins accountable in that regard, but this is teetering upon negligence at this point, because what I've done is they tell me that they don't want me to email my pleadings, and I'm actively looking for the dates as I'm doing this. They tell me that they prefer, and when I say they, I'm referring to Chief Judge Wiggins and Marquisier Hatcher and Ms. Valentine, the other clerks of the different divisions down on the third floor. They tell me, we understand that you're sending the email, and that's what I do as an exercise of additional due diligence to show proof that I've submitted them, because it's been taking so long for him to actually review and approve them. In fact, I just received one approval for an action for filings in the case as it relates to the ZVPO with Jamil Mays, and our hearing is tomorrow. And that was, I believe that was actually positively pushed by Judge Aretha Blake, because that particular hearing, that particular case, had continued to be continued from judge to judge until Judge Wiggins actually took the appropriate action in this case. But give me 1 second. So it would have been February.
Yeah, just give me the dates because I'm going to keep up with my notes.
Yep.
And then we'll start addressing them.
Whenever you're ready.
Yeah, I'm waiting on you.
Okay.
I'm handling something completely separate.
Okay, and I'm going to give you all of the dates. Some of them are resubmissions of it, because at this point I've started, even at the risk of Judge Roy Wiggins not finding that I am, properly doing so. I've started including him because no one is responding to my pleadings. Okay, so April 9th.
Wait, why don't we do it this way? The renewed motion for recusal was submitted when?
It's going to be, I'll be honest with you, it's going to be easier because their emails are voluminous. I can forward them all to you.
No, you can't.
Okay,
Yeah.
so then I can give you the dates because,
Date and motion, because I'm lining them up, each motion and a date.
okay, so this is, hold on, that's Jamil. January 24th, and that was right after his order. So that would have been the motion for the renewed jury trial demand.
Renewed jury trial demand on January what?
Says January 24th.
To Judge Williams?
Yes.
Okay.
And I sent it, and oftentimes he would be included, when I say he, Patrick Johnson, who was the only counsel appearing in this action at the time, he's been included in generally all of these emails as well. And I've included Shayna Steele, I believe it is.
Steele State.
Yes,
All right.
Okay.
So that's that one. What's the next one?
Okay. Actually, let me do it this way. If I do it by the case number, if you'll give me 1 second, because I've got a lot. Okay. All right. Okay, June 30th, 2025. Excuse me, and this would have been the renewed objection to venue and renewed motion for change of venue for fair trial, which are included together. Then the same day for the renewed motion expanding, and it actually is captioned that way, expanding the recusal.
Same day, June 30th.
Yeah. And I also started including Marquisha because I wasn't sure what to do at that point, given that none of my pleadings were being reviewed.
Okay.
Okay, then.
I think the only one that's left is the motion for joint.
Correct. And that one was included in my most recent motion. Yes, it was included in my motion for sanctions. So that was submitted the most recently, and that would have been on, and it's actually in the caption. This is not something, and I can present this to you if you would like.
We'll get there.
Okay, all right, and that is, the date is July 7th.
So that was.
Wait, hold on, I'm sorry. Wait.
So is it a motion for joinder and motion for sanctions?
Yep.
Okay.
Yes, it is. Yeah, not yep, but yes, it is.
All right.
And thrice demand. Yep, on July 7th. And they're very boldly captioned, and Patrick was included in that as well.
Right.
And
so let's start with do you have an extra copy or a copy of the renewed motion for recusal? And Mr. Johnson, do you have that?
I do not. That one, I do not. I don't have a copy of that one because, again, I was not expecting there to be any action taken on today. I can't provide him with this.
the order of operations, given what we filed, would be the renewed motion for recusal and then subject matter jurisdiction.
I agree.
And then everything else. So I need to get my hands on a copy of the renewed motion for recusal
Okay.
so that I can see it, and then make sure everybody else has it. Mr. Johnson, do you have a copy of that one?
When did she say that she's?
This one
So,
has been submitted for
June
review
30th.
June 30th, 2025. And if anybody has it, they can send it only singularly to this clerk.
Sure,
Ms.
please.
Bayo, and then she'll print it for me.
May I please have your email address?
Was it Melissa Donna? Is your middle initial? All right, MELISSA dot Bayo, BEIO, is in boy. And then at nccourts.org. Only send it just to
Yes.
one person, and she'll print it here in court form. And we'll start with that one. Are you able to still get it second?
Yes. I have your email.
Melissa's?
And actually, this one was one of the resubmissions, and it actually is in the court record. I'll give you the
Which
index.
case is it under though? 'Cause I don't.
No, this
have it
case.
in this one.
It is, give me one second. Because you, excuse me. I've been in casual mode for the most of the day, so give me a second with regards to my and yeses. But, because even I don't find them appropriate in the court of law. But what I am referring to is that you had actually ruled upon my motion, but you ruled upon it as to yourself only. And it was including the motion for a change of venue due to, for fair trial on the basis that there are way too many conflicts of interest with too many judges in this county as it relates to me, and the gatekeeper order still being in effect, and Judge Carl Archie not even acknowledging I've resubmitted my motion to vacate the fraudulent gatekeeper order 4 times, and I've received absolutely no response from the Superior Court. So I'll give you that index number. Give me one second.
Well, I don't see index numbers.
Okay.
That's only a clerk version thing.
Okay.
I have it by date and document name.
Okay.
So the last documents that I have, there's a 624 document, order denying the continuance, and then the next documents start on 7-2. So I have
No, that's
7-2 is a notice of appearance and a brief, and then 7-5, motion to quash. I don't have anything on June 30th.
I'll give it to
This one.
Okay, and so that's what I'm referring to. If you'll recall that I said that I had resubmitted some of my motions because they were not being
Right.
regarded,
That's
so
what
I
I'm
re.
wondering,
mhm.
because you resubmitted, because
Okay.
they're by date for me, they're and by name, I do not get the benefit of index number.
Okay, so hold on one second, and I will give you that date.
Nothing's come through on the email.
Oh, because of what I hadn't moved and hadn't taken any action. I was trying to do two things at once.
Yeah, go ahead and send the
Okay.
motion first, and
All right.
they can print it while
All
you're
right.
locating it as well.
Okay. It's in the case. Okay, yeah, no, you're right. So you'll see. I'm just going, and actually I included the staff at Camden as well, but I'm just forwarding it's 7 motions altogether. It's
Are they
easier.
all in one big
Mhm.
PDF document?
Yep.
Okay.
And often I compress them. I just sent
Right,
it.
but I only need the motions and no attachments, so do you have?
Oh.
I can't do the attachments, I just need the motions.
Mine often have attachments. You'd have to give me a moment to detach it in the PDF because they're always.
Forward it, and I'll print just the motions themselves. Because even though there are attachments to motions, I'm not supposed to consider them except for specific motions, and it makes for a very long document.
No, I understand in one regard, but
Forward it,
it's
and
been-
then I'll
yeah.
ask the clerk to parse it out for me.
it's been forwarded.
Okay.
They're all there. There's also, and there was one other, there's one other motion, a motion to stay the trial. And that was done June 25th. I thought there was one other that I'd forgotten. And that was after receiving the notification from, I believe I received a notice of trial date on or about June 21st. And then thereafter, I submit, and it's all in that one attachment because I had submitted them all together with a cover letter.
It'll take a minute. Once you get it, send it to me, and then I'll go through, I can manipulate the print.
And just for the record's sake, I also submitted to Chief Judge Wiggins a motion to vacate the gatekeeper order as well, acknowledging that I understood that it needed to be more properly before the Superior Court judge or the resident or chief judge, but in that the resident and chief judge was unlawfully, unconstitutionally ignoring my pleadings, then I resorted, which is constitutionally proper, to the Chief Judge Roy Wiggins. So my motion to vacate the gatekeeper order, and I'll forward that as well. And again, that's just,
Well, I don't need that one, because that's for them. The gatekeeper stuff is not in front of you today.
The reason why I'm asserting that is, again, because there are due process violations. You may, from your seat, opine that somehow it is not relevant to this case, but if I am not permitted to file legitimate pleadings in this action, then that constitutes a due process violation, and that relates directly to the gatekeeper order. So it's relevant.
All right, thank you.
And I do want to clarify, it is not in the file.
Okay.
It is not. I looked again, it is not. I mean, you understood what I mean. It's not in the case file.
The online case.
Correct, it is not.
Okay, yeah, that's what I understood. We have received. Oh, thank you. I'll read it. Hold on. The name is a lot. Okay.
Yeah, I admit it. It is a lot because I go into great detail as it relates to the fraudulent nature of and facially fraudulent nature of the gatekeeper order and this constant lie that I have filed 164 cases in 72 different counties. The notion is absurd and ridiculous.
I don't have it. It's still processing. It just hasn't moved to the clerk to me yet, so just sit tight. It'll pop up as soon as I can.
May I use a tissue to clean my glasses, please?
Yeah, we should have a couple of document tissues around. I've got one up here.
I have some.
Okay, thank you. All right. Okay, let's see what we have here.
And you are aware, I want to make sure that you are aware on tomorrow that that hearing has been, because it's been rescheduled so many times as it relates to the falsified DVPO that Jamil Mays and his wife effectuated. That hearing is moving forward. Evidently, Chief Judge Wiggins is very aware of that because that's the order I received only minutes before coming into the court. I received that at around 12:45. He took immediate, well, I can't say immediate. He evidently, again, thinking that he was prompted by Judge Aretha Blake, he has approved my pleadings in that case. I'm not sure if I was hopeful that I would get a second email addressing the approval of all of my motions in this case, but I have still, as of right now, I've not received any other emails. But I cannot be here tomorrow, like I told you before, and that was truthful.
The two clerks actually conferred, and you are scheduled for the morning with them, and then here for the afternoon.
It is not, and it is every time that we have, even for ourselves, it is. And this, again, you may think, and again, because this, number one, this case can't move forward, because I can be civil. I'm a very civil professional person and objective. And so there's no need for me to be belligerent because it doesn't serve me well, and it serves me better when the court, when it can be shown that I have proceeded with clean hands. So the point that I'm making is that this case cannot move forward. Whether you opine that or not, it cannot move forward. And on each time that we've had a case before that particular division, we have been told to come at one time, and then we have sat the entire day. And I have 5 witnesses subpoenaed to appear in the court. Yes, on tomorrow. So it is completely inappropriate. And this, again, is not for the cause of delay. It is not appropriate. That is a very convoluted case. And he also, when I say he, Jamil Mays also has witnesses as well. Some of those witnesses, some of those persons are relevant to the case between myself and Camden Noda, and relevant to my subpoena that Patrick referred to with regards to Samantha Morrison, damage to my car, vandalism to my car. Yeah, so it's a lot. It's not appropriate to have it. I can return on Friday to entertain the court minimally, and I'm not trying to be disrespectful, but this case cannot move forward. There's no way that there will be a proper adjudication on the merits in this regard, and so it can't be done.
Ms. McDaniel, hold on.
Mm-hmm.
I'm going through your email. There's no renewed motion to recuse attached to all these documents. I need to start there. I found the motion to stay. There's a handful of attachments. One was the motion for continuance. And what I'm wondering is whether or not some of them are on the same long document, and you just need to help me locate them. But right now I'm looking for that renewed motion to recuse, and I don't find it.
Okay.
I opened up each of the attachments, and I don't see it.
Okay, if you'll give me one moment.
I'm going back through the attachments.
Yes, so it's in the, and I'm going to forward it now, it's in the Quadrice renewed motion for continuance. That's how it's titled.
But is that attached to the email that you sent Ms. Bayo?
I thought that it was. I'm forwarding it now.
All right, thank you. That's the one I need to start with. That's the one. I did print, Mr. Johnson, do you have the defendant's motion to stay enforcement? It reads, counterclaimant's motion to stay enforcement of Wiggins' order denying continuance and cancellation of unlawfully set July 7th trial date. Do you have that one?
He definitely should, because I have also included him.
Print another copy from this.
If you could print another copy, that would be fantastic.
So even where I am not required to notice him when I submit pleadings for pre-filing review, in the interest of time and the interest of the court negligently handling my pleadings, I have included him, and I have also included the Mecklenburg County civil and summary ejectment, or I think it's eviction email, and Shayna and Judge Wiggins. So he should have all the emails. And again, at times I have included Samantha Morrison and the Camden Noda email, to which Samantha responded, directed me to confer with her attorney instead.
Good morning. I'll ask things over.
That's fine. Sure. Nice to meet you, sir. All right. Did you forward that email?
I did.
Okay. Well, let me just Thank you.
And it is entitled S4X Renew. In bold letters, you'll see it. And then because some of those attachments are not related to this case, because again, I have been submitting things combined altogether. Well, I shouldn't say combined. I've just been submitting different motions for all of my relevant cases that require pre-filing review. So the one that is relevant to this case is very conspicuously named S4X Renew. Okay. And just the first page, like she said, it shows in there. It should be, it is 4. Subsection is subpart 4. I request for the renewed motion for continuance, and the fourth reason includes your recusal and voiding by operation of law as to her orders denying change of venue remaining pending before the North Carolina Court of Appeals.
Okay. Mr. Johnson, do you have the motion to dismiss for lack of subject matter jurisdiction?
The one that was filed?
Correct.
Yes, I do have that.
June 13th.
Yes.
Okay. I saw that. Yeah.
I also would like to bring to your attention that Judge Wiggins very often, and I'm not intending to get into his head, I wish that he was here to speak for himself, but even in this pleading where even in his motion, good gracious, even in his administrative order where he approves or denies my motion, and he's always approved all of my motions because again, they are all of my pleadings have been legitimate. He very often has, I guess, evidently there's a template that they have, and that makes sense considering the nature of the pre-filing review. And so where it says hearing/trial, I believe you and the case flow have misunderstood that, because he intended just the motions to be heard before the district court, and that makes more sense because otherwise even Judge Wiggins would have committed clear legal error, because Rule 1016G says you cannot transfer a summary ejectment case from small claims for any reason unless it is specifically stipulated in local rules, and you don't transfer a small claims case to district court on the basis of a change of venue. You can't.
All right, well, hold on. The document I've got, the one that you said that this one was S4X Renew, right? Motion to continue, and that is where the renewed motion to recuse is?
Yes, it's in the motion. So
let me make sure I understand. Is it in the motion for continuance, or is it attached to the back side of it?
It is. So I guess what I would say, instead of just printing out that first template form, the AOC form, that if you go into the document, because the document itself, Melissa, is 157 pages, but if you go into the third page of that document, pages 3 through, give me 1 second, 3 through 15 are the expansion of that motion, and I refer to that.
Is that your memorandum of law?
No, it is not.
All right, so here's what I'm going to tell you. I'm going to tell you what I'm looking at. The document is titled S4X Renew, and I don't know if we're looking at the same document. Motion to continue 071725. So the first page says Quadrice Renewed Motion for Continuance. Mm-hmm. The second page is titled Counterclaimant Defendant's Memorandum of Law. That's page 2.
And that's why I wanted to clarify. That is accurate. However, if you'll continue to read my caption, it refers to not only the motion to stay, but also for the motion for change of venue for a fair trial. And then within the motion, I go into great detail about your refusal.
So you embedded the motion in your...
It is, yes.
Okay, I have to find just the motion.
Yeah.
Because, all right, I have to find just the motion.
So you do have 3 through 15 printed?
No, I don't have it printed. I have to locate just the motion and print just that.
And I'm going to look, excuse me, I'm going to look back into the case because I'm still having the nagging recall that there was also a very specific separate motion renewing my motion to recuse you and expanding it to this jurisdiction, and it being the basis for my motion to change venue. And so I'm thinking that it.
So I can tell what I'm looking at is not, it has arguments, right, that are memorandum of law, but I don't see a motion, a renewed motion to recuse.
Yes,
I'm not seeing that.
Yeah, well, I mean, also keep in mind that there's an ongoing appeal as it relates to your recusal.
Right, I'm
so,
trying to get
yeah.
the motion that you say
Yes.
is filed, I have to address it, and we're now at 2:30 and change, for like an hour, we're trying to get to finding and dealing with the two motions that must be handled before anything else gets handled, but I can't seem to get my hands on.
Well, again, that is not at my fault. I will look here one more time because I'm doing this off the cuff.
If you think you have a motion that you did as a separate document, that's what I need. Otherwise, we'll move forward and you can orally argue your motion to me.
I'm not sure that you're understanding that there's a pending,
And that's part of your argument that's part of the argument that I'm going to hear you on. But I just need to get a copy of the motion and you have it.
Because I remember it very vividly saying in large, I think now I figured out why. Hold on one second. I'm just waiting on my computer to toggle to it. I figured that's exactly what I was referring to. Okay, yeah, yes.
Take down one document and send it over.
Give me 1 second. It's captioned differently. Hold on. I don't need that right now. My computer is not allowing me to pull it up in PDF. Give me 1 second, please. Caption.
Let me know when you got it.
It was actually done on, because it would have been right after, okay, there it is. It's So it's actually captioned Counterclaimant D's Rule 60 Motion for Relief from Fleet's 10/01/24 order, which was not ever heard. And then that was on 10/16/2024. And then that's the one I'm thinking that it may be on my computer at home. I recall that last year I had an issue with my computer and I was using my son's desktop. But give me 1 second, I'm going to try to pull it up.
Motion to continue that you just, or
Correct.
motion for recusal you just did.
Yep, correct. Come on.
Pretty soon, we're gonna have to, I'll hear you orally. I think, I've got Odyssey locked up on the over here. Can you pull this up and let me see the pleadings, please? Is this one? Yeah. Yes, all right. March. That document right there. Yeah, I know, that's what's hard to compliment me, I didn't do anything. Nope.
There we go. Okay, good gracious. Yes, because it includes McCullum, and that would have been necessarily after your January, and it doesn't say renewed. You'll see now.
So go ahead and just email that one.
Okay.
I'll try to manage what's going on with your computers.
This one was on March 6, 2025. Don't lose it. And I'm just forwarding it from, because I had sent it to Shayna, Marion, and Yvonne. I'm not sure who Yvonne is. Let's see here. Forward. Okay. I'm forwarding it to Patrick Johnson as well, but he should, it doesn't appear that he has that one.
Just go ahead and send it this way. So
Okay.
we can get it printed and then we can address that issue.
Okay, because it doesn't appear that he has a copy of that one. That is not, it doesn't appear from, well, I can say flatly. From this email, March 6th, it was sent specifically to Shayna and Shayna alone.
She's a judicial assistant.
Yes, I know. I had sent it to her, because at that point, I was not sending any emails directly to Judge Wiggins at all. I would not just email a judge just off the cuff. So I was sending it to Shayna instead.
Go ahead, did you forward it to Melissa?
I did. Mhm.
Okay, thank you.
And this one doesn't say, it just says motion to recuse Fleet and McCullum.
All right.
And that was immediately after the February 25th hearing. Mhm.
Can you print it for me, please? Just the motions. I need 3 copies. Do I need to call out somebody? All right, let me see if I can get it back up and running again.
I strongly believe that this was actually filed, though. I still have that nagging feeling. I'm going to look back in the system and see.
I had to restart Odyssey, so I can't even look. Give me just a moment. I'm waiting on the computer just forward it to me and then while you're printing it. I just want the motion itself not attached to this.
I have looked again, it is not there. It's not. I'm wondering if it was, because I made a similar pleading in the case with Jamil Mays, and I'm wondering if it was filed in that case. And then I did not file it in this case, and then, of course, just submitted it to, of course, it's captioned for this case and intended for this case. But there was a similar pleading in the other action as well, is what I'm getting at.
All right. Are y'all, did you get her email? Forwarded to the other, it's making me,
I believe the initial, because it should just be one pleading, and I believe it says like MEC submission, that's it. Sometimes I title my files very self-explanatory for ease of reference for myself when I'm searching by word.
This is, I don't have an attachment to this.
It's making it a liquid file.
It's a liquid file.
It's making it that, yeah. I tried 3 times, it's still making it a liquid file. Yeah, no, it doesn't make sense.
Yeah, it's MEC _ submission _ motion.
No, it's the computer system.
Okay.
It's the way it's reading your document. I can't get a liquid file to open.
Would it be better if I attached it? Oh.
No. I just had, it was the way the computer had it open. All right, give me a second. All right, I'm sending this to you. See how that comes out. And I even, if it comes out in 3 seconds. Just quickly, Dustin, do you have a hard copy?
I don't.
All right, I'll hold a third copy. You should get 3.
This is also the one from the DP case that you're trying to purchase?
Right. Yeah, but that's different.
Yeah. And, Capri's has done this. They have a 9, no, they won't. They have another case at 9:30.
Can you pass the email that to me?
I'll do that.
I also wanted to bring to your attention, just in case the DA comes in, they told me to bring my laptop so that they could obtain a recording as it relates to John Neal Mays. So they may enter, just so you know, Clancy Phillips or Anila. I can't think of her last name.
All right, they'll let me know. Okay. I'm gonna print this first page. All right, we should have 3 copies of that. And it should not be printing any of the exhibits. Can I print it all? All right, let me see that. If it's a key, it's just, it's not. This is one. One copy, one I'm gonna send you. All right, this is the one we're starting with. This is the madam's renewed motion to recuse. We will address that one first. After that, depending on the ruling, then we will address the motion for subject matter. And each of y'all should have a copy of the motion as well as I included the cover page to the upstairs to show the date that this is. Each of y'all should have a copy of that. Printing process. I didn't print it. Well, I did print it. All right. Okay, you all should have that too.
Thank you.
All right. Mr. Johnson, have you seen this one before?
No, Your Honor.
All right, go ahead, take a minute and read it. Madam, it's your motion. I will hear from you first. It could be a minute, I will read it as well.
Would you like for him also to see my memorandum of law? I know you said,
I printed it.
oh, okay.
Yeah.
Okay.
The motion is only, the motion itself is short, and the
Yeah.
memorandum is on the back.
Yes, I just wanted to make sure. I hadn't looked over, when she handed it to me, because of course I have it,
Yeah.
quote unquote, so I hadn't looked. I know you said you were only printing out the leading motion, but it's of course appropriate for him to see the memorandum of law. So we just give him a moment to look at that, is that what you're saying? Would you like, so that it doesn't further delay the proceedings that you're intending to have today, would you like a copy of McCullum's recusal?
No,
No?
no. because there
Make
is-
sure that he has it. You want him to have it as well?
No, I don't, we don't need it for this one.
Okay, because she specifies that she's impartial,
But that's, yeah, and that's a separate issue, thank you.
that she's partial, rather. And you sure you don't think that's relevant as it relates to it? Because I feel like Patrick Johnson and his team are going to ask about the February 25th hearing, which you were part of.
Well, just hold on, we're gonna
Okay.
get there. We'll get there. Mr. Johnson, have you had an opportunity to review the madam's motion?
Yes, Your Honor.
She's offered a copy of Judge McCallum's recusal order as it relates to the domestic violence protective order case. Do you want a copy of that?
I don't believe I need it.
Okay. All right, madam, this is your motion. From what I can see in the motion, it references both myself and Judge McCallum. Paragraphs 5, 6, and here's 15, D is in David, and then arguments at the end with the specific issues related to recusal related to me as individually for this court. The court will note that this motion was originally filed with the BDPO file number 25 CD 600-392. There is a cover letter dated March 5th of 2025 addressed to Chief Judge Wiggins, listing a motion to recuse Fleet and McCallum submitting the documents. The only thing, and I'll hear from you now, the only thing that I don't see is this particular case number reflected. So I will hear you on the motion for what is titled Counterclaim Defendant's Motion to Recuse Fleet and McCallum. So as a matter of fact, one thing we haven't done after all of this is swear in everybody. So let's go ahead and swear in the madam, and are you going to have, if we make it there, we're at 3 o'clock, is there anyone that's going to be providing testimony for either the motion to recuse or subject matter jurisdiction?
No, they would have absolutely no dog in the fight.
All right, so go ahead and let's swear the madam in, and then we'll get started.
You solemnly affirm the evidence you shall give to the court in the case now on trial to be the truth, the whole truth, and nothing but the truth on this solemn resignation?
I do.
Thank you.
All right, and let's table here the motion to recuse. All right, madam, as it relates to myself, what would you like to tell me about your motion to recuse?
Okay, so foremost, what we if you'll give me 1 second, please.
Sure.
I took a pause because the question is a loaded one. I am a Juris Doctorate, and these are part of my arguments. You are a sitting judge. I am not yet licensed. You have obtained your license to practice law. And thus, that's how you were qualified to even be considered for election into the seat. In the first year of law school, we learn about bench books. We learn about basal statutory procedural law. You learn about constitutional rights, basal constitutional rights. So the fact that you would ask me and even suppose that you can hear this motion is reprehensible. Constitutional rights include due process. Due process is a cute little legal maxim that has far-reaching implications, both substantive and procedural due process, both explicit and inherent rights thereto. And you cannot defend against apprehending the same. Because this matter of your recusal and disqualification, which is statutory, so you're disqualified by statutory law. Your actions right now are usurpation, and they expose you to sanctions, and validly so, because you cannot be a judge in your own cause. I can say the Latin, but again, the Latin term, the legal maxim, and in that it is a legal maxim. It's so well ingrained in the law that that's what first-year law students learn. So again, you cannot reasonably defend against knowing that you cannot hear a motion to recuse yourself because it affects my due process rights. You cannot defend against understanding that it affects my due process rights because you have severally made orders in this case that you know directly violate my due process rights. You set a trial, a bench trial, knowing that I have demanded and renewed my demand for jury trial, even though you're feigning that you did not know that I have renewed my jury trial demand. You cannot defend against understanding that you knew that I had made an initial demand for jury trial in my counterclaim. You cannot hear this motion. The irony is that you are already subject, or the subject, you are core to the pending appeal in this action right now. And yes, whereas if this appeal involved a substantial right, and so we kind of take this circular space, if you will, because my appeal would not be validly before the North Carolina Court of Appeals as to your recusal unless it affected a substantial right. Because only interlocutory appeals that affect a substantial right are validly asserted and valid before the North Carolina Court of Appeals. And you already know that as well. So there's so many layers here. There's so many facets to my appeal, this case, for which you have absolutely no defense in apprehending and understanding that you are not only, ironically enough, you were subject to recusal prior to the actions that you had taken as it relates to our interaction on the election, on the campaign trail. You've made insolent remarks to me. You've been rude. I do not believe you're a Democrat. I believe that you definitely are intending to infiltrate the Democratic Party just like Tricia Kaufman did and then party switch. And we've had discussions about that in front of churches, on the campaign trail. We do not get along. It is well established that you and I don't get along. That alone is sufficient for your recusal related to the election because the North Carolina Superior Court bench books for recusals very clearly, and all the case law, and again, the statutory law, so statutory being mandatory, which you understand the difference. This is well settled law. This is not law that is still in development, that you would be subject to recusal. Now, the irony, going back to the circular space that this encompasses, the irony is that then you took additional actions. And whereas the initial issue of recusal related to an election was definitely validly asserted by myself, it pales in comparison as to your due process violations against me thereafter. Again, seeking to set a bench trial. That's a number one usurpation in this case for which you are statutorily disqualified by operation of law because it affects my due process rights. Then you continue to take additional actions by denying my motion for continuance, acting in this case at all. Any actions that you have taken in this case at all constitute gross, intentional, and even malicious due process violations because you're on a power trip, to be quite honest. There's no way around it. And the irony is that you're barking up the wrong tree because I'm not the guilty party, quote unquote, in this matter at all. I'm a tenant who has dealt with HVAC issues, a property manager who was being racist and classist and thought that he could get away with whatever he wanted to get away with, and then found out very quickly that I'm not to be played with. And then he thought that he would insert.
Your Honor.
Had an attorney, please let me finish because I'm not saying anything that is inappropriate.
So what I want to do, before I start hearing any of that, I want to redirect you back to those paragraphs in the motion to recuse. Anything that has to do with the eviction or any of those facts, let's stay away from them, because we got to get through the motion to recuse first.
I'm referring to the conduct between you, Patrick, and Steve Moore, and Samantha Morrison.
Okay.
You all have conspired to get me into the courtroom in Mecklenburg County when you all know that there is a validly pending case properly before the court in Wake County against Camden Noda and American National Property and Casualty Insurance. And that is the
I'm going to ask you just to repeat for me the names of those two other people besides Mr. Johnson.
Samantha Morrison and Steve Moore.
Samantha Morrison.
SAMANTHMORRISON, and Steve Moore, STEVEMOORE.
Thank you.
Those are property managers. The initial property manager was Steve Moore. The property manager currently, from the information that I have, I imagine she's still in that role, is Samantha Morrison. Because I have received an email from another, I think Ashley someone, but Ashley, to my knowledge, is not necessarily directly involved to my knowledge. You have circumvented the fundamentals of due process in scheduling a hearing here on a retaliatory, facially retaliatory action that, ironically enough, Patrick dismissed initially, having heeded it. So your actions together, this conspiracy, is doltish. And it brings disrepute on the entire judiciary and the field of law for legal professionals. So it was one thing to be subject to recusal on the basis of the election, being related to the election. I just thought, okay, because when I initially raised it, that was the only premise. You and I do not get along at all. And so it would not be proper, and you know that. You've known that. For you to hear any action for which I am a party. Ironically enough, even Matt Newton and I, we get along famously, or I believe, Matt Newton. We get along famously, and he immediately recused himself. So whether good or bad, there is still the valid basis for the recusal because of our relationship. Again, bad or good, intimate or not. And that was sufficient alone. However, again, after you acted as a judge in your own cause, which you didn't have the right to do so, because that affected my due process rights, you're a reasonable person, because that's the standard, a reasonable, prudent person standard. You would not be able to hear any action for which I'm a party because outsiders, at this point, even clerks and court staff know this. And have questioned me as to why this is happening and why hasn't this been corrected. And again, I go back to evidently there's some type of power trip. I have no clue. Because at the end of the day, there are other judges that can hear this case. Potentially. Because I'm not familiar with all of the judges here. Even though there are lots of judges here for which recusal would be appropriate either positively or negatively. So the fact that you are usurping the presiding over any action for which I am a party is astronomically strange and reprehensible. So then again, like I said, we go back to the circular space. And these are finite, so we're talking about binding legal authorities. We're not talking about, again, nothing that is under development or under consideration or there are varied opinions. This is well settled law. So we go to the bench book for recusals. Excuse me. And we talk about 15A, and this is North Carolina General Statutes 15A-1223. Now, whereas this is not a criminal case, this is why it was raised, or my motion to recuse was also raised, not only in this case, but also in the case as it relates to the DBPO. To which McCollum has concurred. McCollum doesn't like me. And she ruled in that manner, making insolent remarks to me during the hearing, disallowing my evidence that was already filed with the court. And then, ironically enough, she called her homie, you. She called you into the case, said it during the open court hearing that she wanted to confer with Fleet to find out how to best handle my filings, in a very disrespectful and flippant tone at that. It's all on the recording. You're recorded on it as well. That recording has been the basis for me renewing or otherwise filing an additional or subsequent motion for your recusal and hers. That case, whereas it is not directly criminal, it has criminal implications. And because of McCollum's actions, disallowing me to speak, cutting me off, not observing my hearing rights, not observing the evidence that was there, and you telling her, you guiding her through the process for 20 minutes, you all conferred with each other during this case, in front of me, without any regard for my due process rights. And then she found, even though Jamil May sat there and literally said, ironically enough, which I find very, very interesting, when she asked him, has she committed an act of domestic violence against you? He said no. Has she threatened you? He said no.
Refocus you, because I don't want to get into the testimony of the DEPO. Let's stick with, because at this point you're talking about testimony between you and an individual, and it appears the questions from Judge McCollum. But I want to stay focused on this one here in this particular case. What I've heard from you so far is the allegations of my interactions with Judge McCollum during that hearing. I've heard your allegations relating to interactions related to the elections and campaigns. What else do you want to tell me about whether or not I should recuse myself from presiding in this action?
What I have stated, and I'll continue thereupon, is valid as it relates to you, and I stated that because you were physically there. She didn't confer with you over the phone. You were physically there. And I don't know if you recall, because I'm a very wise person, and I intentionally addressed you during that hearing so that you would be recorded on that audio recording, and that you would not be able to feign that you were not present during that hearing and that you did not take action in that hearing. So it is relevant, what I'm saying, as it relates to the evidence that was submitted and Jamil even admitting that I had committed no DBPO against him, and then McCullum, at your direction, finding that I had committed an act of domestic violence against Jamil, and then entering an order to that same effect, which then exposes me, because once a DBPO is granted, then it is reported to a database for sheriff's deputies with regard, and that is criminal in nature. And so the fact that you would involve yourself, knowing that you were already subject to recusal as it relates to me, violates the statutory law that will require you to disqualify yourself and recuse yourself from any other actions for which I am a party. Then we go to the Code of Judicial Conduct. Because again, the irony is that your question is that you continue to say, why should I recuse myself? You don't even have the jurisdictional authority to hear this motion. You can't decide this motion. When it affects a person's due process rights, it is proper under canonical standards, and these are mandatory. So I don't want to give the impression that a canonical standard is somehow discretionary upon the judge who's in question. Then it is proper that you defer it to another judge. And then if you want to defend yourself, you can then present an affidavit in your own defense. But usurping, scheduling a trial, or scheduling a motion, and then doing so without regard for my availability, which is another due process violation, because that violates the Supreme Court standards, Rule 6, which says you can't schedule motions unilaterally without conferring with a party. But you two scheduled, you and Patrick, homies, y'all scheduled these motions, and then it blew up in your face because I wasn't available legitimately for the days that you have scheduled it unilaterally, which is also reprehensible. Exceedingly far, these actions they go far, far beyond shocking any court's conscience. Then you sit before me as though this is, no big deal, I'm gonna maintain this cognitive dissonance, and I'll still hear this case. None of this will land well. Whatever action you take, it will be appealed. Whatever action you take has now been forwarded to the FBI, and I have already agreed to cooperate with federal prosecutors because I've done everything to have the fraudulent gatekeeper order vacated. I've done everything in going through the administrative process. I am a huge pragmatic, and you all continue at every turn to do it your way against the law as though you think you are above the law at every angle. Even as it relates to the sanctions against Patrick, but we'll go back to the recusal here. It is axiomatic. So we're talking about legal maxims. That a fair trial in a fair tribunal is a basic requirement of due process. And it's sad that I even have to repeat this because that's just straightforward. You didn't care whether or not I was available. You didn't care. You didn't care whether or not even this, again, this cognitive dissonance now that you're like, well, what motions do you have that haven't been heard?
Ms. McDaniel, I'm going to ask that you refrain from voices or additional extraneous commentary. I'm taking notes on your legal argument as you're arguing it to me, but there is no need for that.
As it relates to the criminal prosecution that you are now under investigation for, it is valid. because the tone that you have taken with me is completely unbefitting for a sitting judge. I have done absolutely nothing wrong. I've even reported to these dates, with you all knowing that I am not available for this entire week. So referring to your tone is valid because your tone is the subject, it's core to the conduct, the flippant disregard, pattern conspiracy, pattern criminal constructive fraud against me, because this is what this constitutes. You scheduling a hearing when you know that you don't have jurisdictional authority to do so, it constitutes constructive fraud. You taking additional actions and then sitting before this court and me and feigning as though you are somehow in a position where you can hear a motion to recuse yourself is, if I weren't interested in continuing in the field of law for individuals, it would make them want nothing to do with the field of law. But I'm built for this. I'm built for this. Furthermore, I apologize. I have to, because there's an emergency possibly going on. Oh my gosh. Do you mind, please, because there's, of course you mind.
You need to finish your argument on the motion.
She's calling back. I'm going to ask my mother, I need to please answer the phone.
You may go ahead and take the phone.
Thank you.
We'll remain on that. Hello?
She was actually calling me, telling me everything was okay. To continue on, I'm sorry, have we been brought back to?
All right, so let me, and I've gotten it for you before, because that's what I'm doing up here as you're arguing your motion to be taking minutes on an argument. And I think you moved through just about all of it. The paragraph 6 related to my being subject, already being subject to refusal, related to due process violations, related to election in separate, I'm reading it as it is in the other case, related to elections. You've raised the issue regarding Mr. Johnson, the court, Samantha Morrison, and Steve Moore, who you identified as property managers. Quite a bit of the motion remaining as it relates to the hearing with Judge McCallum, except for what appears to be 15D. So let me hear you on the issues in 15B, and then I wish to give Mr. Johnson an equal amount of time to respond. So I'll hear you briefly, but page 6, paragraph 15D, I'll hear you on that section of the motion, because that relates to me. And it appears as though the remainder of those paragraphs relate to the entry of the domestic violence protective order. And then you have your argument, which you've gone through, due process, election, and impartiality. But the issue in 15D seems to be a separate issue that you have not touched on yet, so I'll hear you on that one.
Okay, so my hearing rights cannot be abridged. And I understand that you're saying that you're going to hear me on that, but again, jurisdictionally, hearing rights also entail fair hearing rights, and so I cannot be fairly heard by a partial judge. Because no matter what I say, clearly, your demeanor is exactly that which it is that this cognitive dissonance is that you're going to hear it and then rule against it regardless. And that in and of itself is reprehensible and just calls for you not continuing in your judgeship, which is definitely what I'm seeking, in that I am cooperating with the federal prosecutors. And that is not, I'm not making an idle threat, as I already mentioned before, which is very relevant to this jurisdiction. I've agreed to prosecute all judges, and I've also given Patrick direct notice as well in person. I met with them last week, in fact, at the FBI office off Tryon. Going back to, because your statement was, and I want to make sure that I address that, you continue to flippantly suggest that the DVPO hearing and McCullum's presiding is somehow unrelated to you. And I want to reiterate that it is absolutely related to you because, again, McCullum called you in very specifically and conferred with you, and you all laughed on record, you taunted me on record. It's very disturbing, quite frankly. So all of that is relevant as it relates to any other case for which I would be a party.
Well, it's not that I'm telling you that it's irrelevant. You've argued that part to me. I want to hear you on the final part that specifically relates to me by way of your motion. Not that the court thinks it's irrelevant, it's just that you've given me all of that information. And the section that I'm looking at is 15D. And it appears that the allegation is that I conspired with Judge McCallum and the deputies. That's the part that I'm referring to. So that's what I will hear you on, and then I will hear from Mr. Johnson.
Okay. You must hear me on the totality of my hearing rights, even though, again, this should not be before you at all. You are statutorily disqualified from hearing this. Again, I'm doing this in due diligence as it relates to my FBI complaint because they told me to keep the course and keep your composure, and then they'll gather all the evidence that they need. And then I know that I do this as well for appellate reasons and relief reasons because there will very swiftly follow a motion, a Rule 59 motion, where, and if necessary, just like I filed the motion for my Rule 60B motion for relief from your initial motion to recuse, your initial order denying my motion to recuse you as it relates to the election. Returning to the bench book, when recusal should be decided by another judge, if the allegations made about the judge's bias or other potential disqualification are made with sufficient support to require findings of fact, the motion to recuse should be referred to another judge. And that is in Ponder versus Davis. The judge whose impartiality is being questioned then may respond by affidavit or testimony to rebut the allegations. but you do not have the authority to usurpedly hear the motion to recuse as it relates to yourself. And it is supported by sufficient evidence. Which is also part of the legal maxim. Going to paragraph 15, this is what I found particularly demented. And I reckon that you all thought maybe I would act out, maybe? It was very strange, very strange. I'm a lady. I'm a very sophisticated lady at that. And few have, and I don't mean this arrogantly because I don't, it's very important that I say this as it relates to your recusal. My parents raised me to be ambitious, but not arrogant. And so with me having a Juris Doctorate and a PhD, I'm unrivaled as a black woman of Haitian descent. And in the applied sciences at that. So and going back to 15, so when you all, during this hearing, because this also carries over to Paul Ridgway, and this is relevant to you as well, because I've been running for office since 2016, so this goes into the being related to the election as well. This gatekeeper was started on the basis of a political bullying campaign smear tactic. And it's quite interesting because, again, the notion that I could even file 162 cases in 74 different counties is not even plausible. During this time, the truth of the fact is that I was in my PhD program and my Juris Doctorate program, which few in this world have done. The reason why that's relevant is because you all have been incessant on trying to figure out, and you're using the premise of this wrongful conviction that I experienced in 2006, which has been proven to be wrongful. But you're using that under the guise that you're going to tell the world through the campaigns that I'm a bad guy, that I'm probably a criminal. She's definitely a criminal. And quite frankly, it's psychologically disturbing at one point because nobody believes it, but you all. It's a lie that has just been in the mix of the co-conspirators. Everyone outside of it thinks it's foolish. They see my character. It doesn't match. I was a TA, a single mom, running my own business and running for office in a JD and a PhD program, and you put out a lie that I filed 162 cases in 74 different counties. And now it's come full circle because now that the courts are integrated electronically, your gig is up. Because it's showing that
I just want to make sure I'm following. Are you referring to the original gatekeeper order that was entered?
I'm referring to the bad faith, corrupt enforcement thereof.
All right, but this paragraph relates to McCallum did also evidently conspire with Lee and his deputies to effectuate a defunct Wake County arrest warrant.
I'm referring to that, and you already know, the facts behind this. You're just feigning that you don't.
Right.
Paul Ridgway.
Here's what I'm telling you. You've been arguing the motion to recuse for almost an hour. I'd like you to wind up your argument because at 3:30, it's 3:35. I need to be able to give Mr. Johnson equal time to respond. If he doesn't use all that time and you have further information, that's fine. But that is a policy of this court that the time gets divided equally, and I do that in all of my cases. So I will ask you, madam, to please wind down your argument related to the motion to recuse as it relates to the motion that's in front of you. And then I'll give you about 5-6 more minutes, and then I'll hear from Mr. Johnson.
I find it very interesting, so I just put it on record again that your actions and even your statements right now.
Y'all need to be mindful of your cell phones, please. It's a recorded courtroom. It's disruptive. Take it outside and fix it. Sir, take it outside and fix it. Continue, madam. You were interrupted.
What's very interesting is that this has been a decade-long, large-scale pattern of conspiracy, public corruption, and constructive and actual fraud that you, Paul Ridgway, Patrick Johnson, Grimes, McCullum, Archie, Watson, Katrina Watson, and the list is near endless, including at least 20 judges and attorneys who have held out that I am validly subject to a gatekeeper order because I filed 164 cases in 74 different counties of this state, which has been proven to be a lie. Not a misrepresentation, because I, as a pragmatic, I thought, well, maybe there's just a misrepresentation. Maybe it has to be, because I'm pragmatic. I'm also a lawyer. There's no way that they would engage that level of fraud upon the court. But you did. You did, and you did. You had absolutely, it could care less. He filed motions for sanctions as it relates there too. And now he's validly subject to the sanctions, as well as Wilson, for regurgitating this knowingly falsified, immeasurably disgusting lie. That's not even plausible. And the reason why this relates back here, and the fact that you would say, well, I'm going to give you 5 more minutes, but you spent a decade terrorizing me, but you think that you can give me just 5 minutes to be heard on this, that's another reason why you cannot proceed in presiding in this case. Because you will continue to limit my arguments under the guise that you're doing it fairly to hear from the other side. And that's not how that works. That's not how that works. Constitutional law is well settled that hearing rights are just that, substantive and procedural. And so I deserve to be fully heard, especially considering after a decade long of lies by judges and attorneys who have conspired, who need to be criminally prosecuted. During this hearing with Paul Ridgway, or relating thereto, after McCullum and you conspired the fraudulently effectuated, wholly unmerited, I didn't even argue with my ex-boyfriend when all of these things happened. So I've committed absolutely no conduct that would even rise to the level, even the notion of it rising to the level of domestic violence. The things that they did to me are just unheard of. So as I compose myself, because I know at the end of the day, and I'm so thankful for my parents, I continued to keep my composure because I knew that I had options for relief, and I rely upon the truth, and the truth has always served me well, exceptionally well. And then the bailiffs came and taunted me You all, it was very obvious. You see, and you know this, and because we had this conversation on the campaign trail as well, that I'm a former federal ranger. And that scope of work entails investigative acumen, high legal and ethical rigor. What I'm getting at is that I was then approached in a circular fashion by bailiffs taunting me and then saying, well, we have to arrest you. You've got a warrant. I don't know of any warrant. I don't believe anybody's perfect, but honey, I am as close as it gets. I'm it. And they put me in handcuffs, and it was though you could tell their behavior, and I'm thinking to myself, why would I be fearful of what you think you're going to do to me? Please understand, I needn't engage revenge or anything like that, because at the end of the day, there will be final justice, and I will be very glad. And so then they arrested me, and they were laughing during the hearing. You can hear this, and I refer to it in this pleading, the laughter between you all, I guess thinking that I was going to act out so you would have a reason to then rough me up. For what? You're the problem. You're basically giving me a compliment in a backwards way. And I'm just going to watch you die upon your own sword.
All right, so we're at just about 3:45. Right. We'll give a couple of extra minutes. I'm going to hear from Mr. Johnson now on the motion to recuse. The gentleman has an equal amount of time. If he doesn't utilize the time and you have any responsive remarks, I'll hear you at that time. Mr. Johnson, your response to the madam's motion to recuse.
Good afternoon, Your Honor. Morgan Reese. This afternoon, I'm going to be addressing some of the pretrial motions that the court's going to hear.
All right, the only one we're dealing with is the motion to recuse.
Yes, Your Honor. I think in kind of sorting through where we are, I'll just make a couple of very brief points. First, this court has jurisdiction today. The appeal that's pending in the Court of Appeals related to the court's original recusal order is an interlocutory appeal. Appeals of recusal orders do not affect a substantial right, are interlocutory.
Well, no, I'm going to hold you on that. The court's issue as to whether or not I have jurisdiction is the subject matter jurisdiction issue. I recognize that that is part of the madam's argument, but I have to get through the gate of recusal first before jurisdiction, and I do not wish to conflict the two. Just stick to recusal and the madam's specific allegations when it comes to her motion to recuse.
That's fine, Your Honor. As to recusal, Your Honor, let's just go back to the standards for recusal. The party moving for disqualification has to objectively demonstrate grounds, and that must be substantial evidence that there exists a personal bias, prejudice, or interest on the part of the judge to demonstrate impartiality. Your Honor, that is demonstrated by substantial evidence. In this case, she has not brought forth substantial evidence of bias, prejudice, or interest, whether it's in any of the items in her filings or what she's brought forth orally this afternoon. The second part of her argument, I think, Your Honor, involved the consideration of a different judge hearing the recusal motion. The standard for considering that particular request is whether there's sufficient support to warrant specific findings of fact. That also has not been met here, Your Honor. The narrative that's been provided by the court is vague. It's not supported by detailed, specific findings. None of this rises to the level of necessitating a different judge deciding the recusal order, the recusal motion or it also doesn't rise to the level of this court needing to recuse itself. Simply, the defendant in this case has not met her burden here, and we would ask the court to deny this motion.
Madam, do you have any response to the?
Of course,
counsel's,
absolutely. So number one,
So we got, so the three assertions that I have from the Madam
I broke them down.
on one is about retaining jurisdiction notwithstanding the appeal of the recusal order of previous defender. The Madam's argument is standard for the entry of a recusal order, and the standard is to whether or not another judge needs to hear the motion. What is your response to each of them?
as a Juris Doctorate, I had already taken note of her arguments and intended to direct my rebuttal thereto and then expand thereupon, and do not need any further direction from the court as that.
Your response?
The plaintiffs in this action, who are more factually defendants in the preceding complaint against them, and American National, I'll refer to in an abbreviated manner, they don't have a dog in this fight. She cannot provide any evidence to rebut the evidence that I have seen and that I am giving testimony thereto. Not all evidence comes in the form of documentary evidence. Testimony is valid evidence. And I have been sworn, and I am attesting to the evidence that I have averred in my motion and all of my other pleadings, which I have maintained consistently. It is not questioned. In fact, again, and that's very likely why Patrick didn't stand and give any argument thereto, because his motion for sanctions is laden with the regurgitation of the lie of the 164 cases that I supposedly filed in 74 different counties of North Carolina, notably, ironically enough, before 2017, nearly a decade before there was e-filing. So evidently now I'm Casper the Friendly Ghost and I'm not present and can move about unlike anybody in the world and accomplish a feat like that within a 3-year span. This same nonsense is the basis for the fraudulent gatekeeper order in this jurisdiction. And whereas you did not enter that gatekeeper order, you are enforcing it in bad faith and corruption, public corruption at that, which exposes you to being validly unseated because you've been elected and you can be unelected as well. As it relates to her argument that it was vague evidence, here in the very plain language of the canon, because she's a licensed attorney as well. They're both licensed attorneys. I'm not licensed yet, but yet I can read this very plain language without any hemming and hawing about the stipulations therein. The bench book reads, actual versus perceived partiality. Canon 3C, not just statutory law, but canons, judicial canons. Canons being the legal maxims for judicial conduct. It states that a judge should recuse when the judge's impartiality may be reasonably questioned. We're done. We can clock out, go home. We're done. Your impartiality can be reasonably questioned. I've already shown that. You had no business in the case with the DVPO. Had no business whatsoever. You're not a chief judge. She's not a chief judge. It would have been one thing if McCullum actually thought and conferred with the chief judge. That makes sense. You have no more knowledge than her, and in fact, you didn't add anything to her knowledge in that case. It was my statements, ironically enough, in that case that cleared up the confusion, because neither of you realized that there's a very simple statutory procedural law that requires that you do hear and regard my answer and affirmative defenses and counterclaims in a DVPO case. You two sat up there and very doltishly, very corruptly mocked me, taunted me, and thought that you would just get away with it. And then you completed the act of the specific harm against me by entering an order against me for a DVPO that I didn't commit. And the irony is that the man who did do all the crimes and torts is the man that effectually, for a time, has gotten away with it. Until, ironically enough, Chief Judge Wiggins got a hold of it, and he's going to hear the motion to set it aside tomorrow because it is completely fraudulent.
I'm going to redirect you in responding to Madam's 3 or 4 points that she raised. Specifically, 2 of them are the standards for my entry of the order. Your response to her argument that standards have not been met.
The standard, as I will return the court's attention to, is where she talks about vague evidence. There is a far exceeding amount of ultima facie evidence in the February 25th hearing, which was recorded with you and McCullum taking so many grossly inappropriate actions against me, which constitute numerous due process violations against me. And that recorded hearing, because that's your property, that's in the custody of this court. I didn't record the hearing myself. Me bringing you literally into that recording by addressing you, and you clearly not realizing what I was doing, made sure that you were recorded on that it was known that you were not going to be able to walk in there and chit-chat with your homie to do dirt to me and then walk out and get away with it. You're recorded on that hearing. Your behavior on that hearing, during that hearing, is recorded. And that is not vague evidence. That is legitimate evidence that is a audio recording captured by the court of law, and you can't escape it. So it's far exceeding vague. It's far exceeding perceived partiality. The actions you all took in that case, and again, as it relates to Paul Ridgway, because again, this is the convoluted nonsense of this continuation of this large-scale fraud. And I got out of custody the very next morning. Oh, excuse me, not even, it was 2 hours later? No, it was 4 hours later. It was in the morning, like 2 o'clock in the morning. So you all would subject me to criminal persecution unjustly. You will subject me to civil actions unjustly. That is proven. This is not a supposition at this point, because you engaged acts with McCullum, and thereupon you carried out the very specific act which was core to your conspiracy in the first place. That's not vague evidence. That is ultima facie evidence. You have no jurisdictional authority. It is a legal maxim that it is automatic. It is not something that then has to be decided by another hearing whether or not you're disqualified. There's a difference, even though recusal and disqualification are used interchangeably generally. Disqualification has a very different meaning, and you know this, than recusal. So you're not just subject to recusal, and that's the reason why my motion is enlarged as it relates to your disqualification. That's the reason why you are referred to in all of my hearings in the caption as disqualified fleet, because you are statutorily disqualified by operation of law. There's no pleading since June 30th. All of my pleadings refer to you as disqualified fleet, because you continue to engage acts that are condemned and prohibited by law because it impacts my due process rights, and you don't care. That's additional evidence, additional ultima facie evidence, which can be inferred directly from your conduct, because you continue to say, well, now I'm going to set a hearing. I'm going to set a trial. I'm going to set a bench trial. I've got at the very least, you would think, wow, maybe she will schedule a jury trial. If she doesn't have bad faith intentions, then she would just schedule a jury trial. Because there is enough information, enough claims, well supported with documentary evidence in my counterclaims to show that if we were going to have a trial in this case, or rather to resolve the dispute between the parties, and you understand the reason why I refer to it in that very specific language as opposed to a case, because there is a preceding action that's already addressing this. And Patrick thought, hey, let's skip the law process, which is another you and him. Same conspiracy. This is additional ultima facie evidence that you have no intentions of observing my due process rights. You just want to give the impression that you're doing it through cognitive dissonance and then rule however you want to. Oh, I'm going to be nice to her in the court of law so that nobody thinks that I have a bias against her. That's not how that works. That's not how that works. It's not how it works. Finally, even though I understand that you said that you're not addressing the nature of the interlocutory order, that circular space, that's the circular nature of arguments that is wholly baseless, completely convoluted. My appeal would not be validly pending, and it would be dismissed sua sponte by the North Carolina Court of Appeals if it were not proper. It is not. It has been in the briefing stage. We have every step that I'm supposed to undertake to perfect my appeal has been done. And they infer from their conduct know that because Nathan Wilson, on behalf of CUSA, has requested, because Patrick took no action, which I thought was very strange during the entire appeal process, and this refers to you as well. He took no action because, again, remember, the appeal is directly related to you and your orders, which constitute void ab initio orders. And you know that legal maxim as well. That means that they are void on their face, and it constitutes nullity because you were disqualified statutorily from hearing any matters for which I was a party. That includes the motion for change of venue and objection to venue as it relates to my right to a fair trial, and your decisions, your denial orders as it relates to motion to recuse. In fact, you've denied everything. Anything that I have filed, you have denied. That's additional evidence, because we're not just talking about you just making rulings in a case and then I'm just being aggrieved and, I'm the unhappy party because it's not being found in my way. This has nothing to do with that. Because, again, we go back to, if you had good intentions, you just schedule a jury trial. If you had good intentions and weren't acting in bad faith and corruption, then you would literally say, okay, Ms. McDaniel has a hearing on the 16th, and Patrick, I'm going to warn you because you should have conferred with her to schedule these motions because, number one, they're my motions. They're my motions. How in the world are you going to schedule my motions? Even where there is a minimal option in law that allows for the opposing party to schedule another person's motions, that's the reason why there's Rule 6, because you would very likely, stands to reason, you would like to know when the other person is available whose motions they are. And then even during this last hearing on July 7th, which is further evidence, you literally accused me of not being truthful about my lack of availability on days that you didn't even consider and regard my availability. You don't have good intentions as it relates to me. You are biased as it relates to me. You don't like me, and quite frankly, I don't like you. And that is very clear. You and I both know this. You should have recused yourself as soon as you laid eyes on me during the hearing, but you didn't.
All right. Given the amount of arguments, if there's anything additional to the final information that I hear before I review my notes and issue my
There.
counsel, anything that you wish to respond to, the madam has raised the issue amongst responding to the arguments you brought before. She has raised the issue regarding the pending appeal of the North Carolina Court of Appeals. Given that the madam has raised that, are you doing the same response?
Your Honor, if the court wants to hear about that appeal and whether it divests jurisdiction, I am happy to have that conversation, or if the court would rather.
I can tell you how to argue it to me, but I can tell you that the madam has raised the issue, and if you wish to respond to that, the court will hear you.
Your Honor, then just briefly, it is an interlocutory appeal on this court's original recusal order. That is not an appealable order. It is interlocutory. It does not affect a substantial right. Your Honor, there's a case, Louder versus All-Star Mills. It was cited to this court in our July 2nd brief that we filed and served.
Do you have a copy?
I do have a copy, Your Honor.
All right. Do you have a copy for the madam?
I do, Your Honor.
And if you're going to refer to any other case law, the madam copies which she can review it.
Correct.
While I'm here as well.
I certainly will, Your Honor. If I may approach.
Yes. Yes.
Your Honor, this case makes it clear that a ruling on a motion to recuse a trial judge is an interlocutory order and is not immediately appealable. Given that, it does not, having that pending in the Court of Appeals on appeal does not divest this court of jurisdiction in hearing any other matters in this case. What I just quoted to the court can be found on page 2. Under Braswell, comma, judge, bottom right hand of the opinion, first sentence.
All right. Anything else?
Your Honor, there are only two ways that appeals that are interlocutory can divest this court of jurisdiction. She hasn't satisfied that because this is an appeal of a recusal order. This court has jurisdiction. This court can act.
Yeah. All right. Ma'am, let me know when you've had a chance to review the case. I'm looking at it as well.
So as a scientist, doctoral level scientist in applied sciences, looking through a microscope at the things that we can't see with a naked eye, and then going to law school, it has served me exceptionally well. Unrivaledly, exceptionally well. This case law, and what I've often found, which actually is very surprising because I had such a profound respect for licensed attorneys prior to, especially in North Carolina, but it's fast changing because their ethical rigor is questionable. This has absolutely nothing to do with this case, has nothing to do with my interlocutory appeal, because as I have stated, from federal statutory procedural law, when an interlocutory appeal affects due process rights, very specifically, and they are invoked by the appellant, then this jurisdiction, the court below, is divested of jurisdictional authority. Coupled with the fact that inherent thereto, for the recusal, as I've already mentioned, for your disqualification, not just your recusal was a matter before the court prior to your additional acts. All of your additional acts of due process violations, gross due process violations against me, now subject you to statutory disqualification. My motion for change of venue is directly at the forefront. The motions in this case in this case law, they have absolutely nothing to do about change of venue. The specification as it relates to my motion for change of venue for a fair trial, which I thought, wow, what should it matter to y'all at the end of the day? Just transfer it to another county where I can get a fair trial, then we can have this case squashed in no time. We can have our jury trial, and they can be found liable for all of their torts against me. Why must you have it here? Why? Because this is where I'm subject to a fraudulent gatekeeper order that you all effectuated. Why must I have it before you? Why you specifically? Why not any other judge? Judge Fleet? Why no one else? Because it's obvious what your intentions are. When it could be very so easily handled in a lawful and fair way, which cannot be disputed on any way, shape, or fashion. No way, shape, or fashion. This has to do with the recusal only, not as it relates to the motion for change of venue, which is very specific to this particular case. And that was raised in my response in opposition to that, and that's what I was referring to earlier, if you'll recall. On July 2nd, I received, and it has the most disgustingly Rule 11 violative statements about me. And that's what made me move for sanctions against Nathan Wilson. But on July 2nd, I received a brief in support of this court proceeding on Camden Apartments complaint for summary judgment. And in this complaint, he similarly, argues that jurisdictional authority has not been divested. But they do not cover the fact that your order specifically, as it relates to change of venue, are the reason for me also seeking the motion for your recusal. They are the issues that I have raised on appeal. It is core to that. Too often, way too often, licensed attorneys in North Carolina, very specifically, even more specifically in Mecklenburg County, I guess they think that maybe since I'm a new graduate, I can't read. I was a scientist before. I am still a scientist now, doctoral level. I read way too much. I enjoy it way too much. I get lost in the words. I love the words. So I'm going to read. The case law is exciting to me. And it does not have anything to do with this case.
This being the case law.
The case law that she just presented has it is, as it relates to the recusal only. Okay. And it does not show where the recusal for, and hold on one second because I'll bring that up. Give me 1 second.
We're just about done.
Sure.
When we get back and forth, like this, the only thing I want to hear you on is case law. That's it.
Sure. I don't expect anything less. Pretty certain I printed out a copy. I think this is it. Oh, yes. It's in my email, not that much. When I find it, it is a one-liner from binding federal law.
You looking for a case? Is that what you're looking
No, it's statutory. It's not case law.
Once you look at it, it's being decided.
Mm-hmm.
So I can pull it up.
Since oh, it's just easier. I just pull it up. Rules. '28 U.S. Code. 28
USC
Mhm. 1292.
1292,
Mhm.
any particular paragraph?
Oh wait, hold on. This is. I'm sorry. Hold on 1 second.
Is that the right one?
No. Oh, so there you go. That refers to the orders. I was trying to pull it up quicker instead of fishing through here, because I refer to it on appeal. Let me go to mine. It's Rule 5 of the federal, the Rules of Civil Procedure, and then it, because it's in the annotations as well as it relates to 28 USC 1292 and the interlocutory appeals for matters that directly affect due process rights. And you can't just take that out, because we're talking about balancing equity here and the status quo. We're also talking about.
Hold on, before you continue, you're talking about Rule 5 of the Rules of Civil Procedure and 28 USC 1292.
Mm-hmm, yes, and then also. Trying to pull it up from mine.
And this is as it relates to the court's jurisdiction pending appeal.
Right, it being divested. It's, well, when you look at that's why I said, when you look at the immediate rule, 1292 is speaking about the order itself, and so it's effectively talking about what happens thereafter. And then, because of course the motion for a change of venue would constitute an interlocutory order, and then therefrom, when I appeal, then it would constitute an interlocutory appeal, and it would be an interlocutory appeal by right because it affected my substantial rights to due process, and in that it was related to the motion to change venue and not just as it relates to just recusing you. Well, this was not a separate motion for recusal as is what this case law goes over. Yes. Valid issue of whether recusal was proper. In this case law, recusal was not found to be proper. So in that regard, has absolutely nothing to do with this case. But as it relates to the ancillary matter, which goes directly to my due process rights as it relates to change of venue for fair trial, which would, when you're talking about an interlocutory appeal, and this would have finality, and if I would not be able to raise these issues on appeal because the action would have already resulted in my irreparable harm. And that's what that refers to. And that is well decided case law. So we're not just talking about, whether or not you, now if we were back at the issue of you being recused related to the election, I would have no direct argument as it relates to that. Because at that point, even though it did touch upon due process, at that juncture, it was just a matter of preliminary measures to preserve my due process rights, as opposed to being able to finitely prove at that juncture that my due process rights, that substantial right, had already been abridged. At this juncture, there's no question at all. My due process rights, you haven't observed. You haven't observed them. Even if you want to take out, and you can't take out February 22nd. And again, we go back to, and I don't need to repeat it because it's finite. If you intended to observe my due process rights, there are several ways, very easy ways you could have already done it. But you haven't. You continue to take action that goes directly to my due process rights, and specifically as it relates to motion for change of venue, which is a very, very serious legal maxim.
All right. Okay. Give me a second. I want to leave the rest of this case in context, and then because it goes to the heart of
Your Honor, if I may briefly, we cited a couple other cases that will put all of this into context, the interlocutory appeal,
Right.
the authority of this court.
Right.
Ma'am, please. That's why I asked if you had any case law at that time.
I understand.
Get to her so that I can move on.
Your Honor, I apologize. Your Honor, I have two cases. They were cited in our brief. It's Plasman and SCD Holdings. I will be happy to provide them to the court.
What are their principles?
Your Honor, they stand for the same principle that we've been discussing. We have Plasman, which stands for this principle that an interlocutory appeal does not divest this court of jurisdiction, and that a recusal motion and order is an interlocutory appeal.
Is that redundant to what I have in front of me?
Well, Your Honor, I think that I'm saying.
Ma'am, it's late in the afternoon. Please do not yell up. I am asking her for a specific legal argument for a specific purpose. And it's irritating to me that I didn't get it when I asked for it the first time. Why is it not duplicative to what I have in front of me?
Yes, Your Honor. I'm just trying to provide the court with everything, and I apologize for not doing it earlier. Your Honor, it goes to the proposition that the court need not stay proceedings, but may disregard the appeal and proceed on the action while the appeal is pending. Before an interlocutory appeal is properly disregarded, a substantial right analysis must be done by the court. The case that I handed up tells you that this is not a substantial right. This just puts it in context for the bigger picture. I apologize. The other one is SED Holdings, Your Honor, and SED Holdings also is kind of the next step in the process, Your Honor, which says that even if this court were to decide to go forward to hear the case during the pendency of an interlocutory appeal, And later, the appellate courts in North Carolina decided that it did affect a substantial right. If this court's decision to go forward is based in reason, then it will be upheld.
All right, let me see them, give them to the madam.
And none of that would apply here because,
Don't say anything, just want to look at it before I can decide on taking it. So go ahead and give her a copy and let me know. All right. Did you get copies of my
I did, Your Honor.
may I please, because I'm familiar with these.
I'll read it first. I want to put it in my head first, just a minute.
This was 1L for me. My dean, yeah, this is 1L for me.
Sit tight, Madam.
Okay.
Thank you.
It's not related.
What's the caution on SED?
I'm sorry, and which one, Your Honor?
SED, what's the caution on?
Yes, Your Honor.
I can answer that for you.
No, the madam presented the case, it's her responsibility for it to be checked out.
I was waiting for the
Oh,
court.
no,
I'm sorry, Your Honor. No, Your Honor.
What was the caution on that case for?
Your Honor, so SED and plasmin, are kind of an arc. So SED comes out in 2016, Your Honor. Another case called Tetra Tech then comes out, and then Plasmin comes out. So SED's yellow flag that the court is asking about is related to Tetra Tech, which was a different circumstance of an interlocutory appeal and whether it divested the court of jurisdiction. And then we have Plasmin, which then also further discusses this context of when the court is divested of jurisdiction.
So Plasmin is after.
Tetra Tech, yes, Your Honor. And I'm happy to give the court the Tetra Tech site.
Please.
Hold on just a minute. 16, 17, Tetra Tech is 16. So we have November 16, December 16, and then the most recent narrowing of interpretation being May 17, being Plasmin.
Yes, Your Honor. And I think Indeed, Your Honor. I think Tetra Tech really just reaffirms that a court can act reasonably in moving forward in retaining jurisdiction. It just held in that case where there was a mandatory injunction. It found as a matter of law that the interlocutory appeal was proper, which is of course different than our circumstances. I'm happy to answer any more questions the court may have about any of these cases though.
And if I may now, that's exactly, I love my dean. My dean is excellent.
Your response.
I remember this very vividly from 1L. That'd be my first year in law school. And as it relates to the Tetra Tech, that came back very quickly. And so I'm glad that she actually told the truth. Tetra Tech, in this case, there are similarities and they favor me, not their argument. As it relates to the fact that the court at the lower court, the court below, could not reach these issues because the appeal was plagued with so many jurisdictional problems, very similarly to this, stemming from the way it was handled. And it was found that the appeal was properly before the North Carolina Court of Appeals as an interlocutory appeal, and in fact, as it relates to venue. And that's what I have most commonly found with the case law, that any of the North Carolina attorneys submit in rebuttal to anything that I submit, they fail to they fail to do their due diligence in looking at the cautions and looking at the specificity of the case entailments as it relates to trying to then prove up IRAC for the case that they are trying to use as substantiation, oftentimes relying upon a paralegal and not doing the due diligence themselves, and that's where they slip up. The change of venue is relevant as to this court being divested, because this is not just a matter of preliminary injunction where you just have the issue of the status quo being maintained. Change of venue is one of those constitutional rights that goes so far into regarding the proper regard of one's due process rights that it cannot be abridged. That's why my issues on appeal specify it very clearly. And it's very likely why Patrick took no action in the first place for the entire duration of my appeal until Nathan Wilson appeared only less than a month ago asking for more time to then respond in a response brief, because they know that my appeal is proper, inferred by the request for an extension. Even if he was just doing it just in case he was unsuccessful in his knowingly frivolous brief in support of the court proceeding on Camden Apartments complaint for retaliatory summary ejectment as it relates to trying to get this court to believe that somehow my appeal is not valid, number one, because again, he makes such insolent remarks, like I'm a free riding tenant. Yeah, ooh. The fact that even this court, because if I had done it, this court would have sanctioned me, would have suggested that it would hold me in contempt for not providing the full picture. That was a known misrepresentation, and there's no way around it. And she's only coloring it, like with window dressing, to play nice so that she doesn't get in trouble. The case law does not have anything to do with this case. You are without jurisdictional authority to hear this motion for recusal. You are without jurisdictional authority by statutory law to hear any matter for which I am a party. You are without statutory authority to transfer this, and that's another thing, because that is in there as well.
But we're not hearing that right now. All right, I'll put it up on the motion to recuse. Give me a moment, please.
Your Honor, I would like to reiterate that part because it is important, because that's another due process violation that you committed against.
I am complete in the hearing. Thank you.
Okay, so I would like to make sure that that is noted on record, that I'm being disallowed to continue my argument.
Yes, ma'am. Arguments are complete. Thank you.
Which constitutes another due process violation.
Ma'am, the court will know nothing else from either party. Okay. I could pay this order, but I'm ruling is that I'm denying the motion. I'll pen the order this evening and have it with the clerk for file. They'll probably be done after hours, so it'll get filed tomorrow. All right, with regard to tomorrow, we will begin with the matters motion to dismiss for subject matter jurisdiction. I asked Madam Clerk Nadeau to get in touch with either the clerks on the other case or the judge's clerks to determine the amount of time that had been set aside for the other motion hearings that Madam has to attend. What did you find out?
Did the 30 minutes of what was scheduled?
Where did it meeting held?
81.
What is it? 81 on having heart disease. 81, so it's at 81:50 at what time?
No.
Is it a motion calendar in the morning that there's a bunch of them set for 9 o'clock?
There's something scheduled at 9:30.
So is that how they do it there, that they get a specific time and they get to show up at the same time?
That's what I understand.
Can you pull it up and one time for tomorrow so that we plan it properly and everybody has enough time to do the things?
It is grossly improper.
Put her in a position where she's got to be in two places at once.
I won't. That is a criminal matter that I need to have vacated, and we will be there, and it takes precedence over this. I will not be here on tomorrow.
I'm gonna ask you to hold, please, while I get information from the clerk.
I'm also giving open court notice of appeal from your legally erroneous order denying motion for recusal. And I'm preparing this written motion to be entered, and there can be no further action in this matter.
What are you trying to, what's on the docket tomorrow?
I'm looking to see.
Yes.
Also on record of the court, asking for a copy of the audio recording of this hearing as well.
The clerk will give you those instructions, they all handle wrong.
No, they will not accept any of my paperwork. No forms will be accepted without there being approval from Judge Wiggins, which you are fully aware of this. And so I'm making sure that it is noted on record.
Thank you. Enough. There'll be no more conversation on record today.
Again, then that means that we cannot move forward with this case.
Ms. Daniel, do we have the forms here or is it illegal?
It's early to forward.
But she can't do it through the form, so do we have the form here so that I can accept it now?
No.
So then how do we get her a copy of the recording? Okay. What's on the calendar? Can you tell us? Can you tell us what's on
So it's an add-on hearing scheduled for 9 o'clock for 30 minutes. They have another motion.
I just do it louder so everyone.
They have a motion for preliminary injunction, a motion for Rule 70 on another case at 9:30.
So, but I only want to let this one. So this one set for 9 o'clock for 30 minutes tomorrow morning with the man.
Correct.
Where the matter has to be. And then she has a 9:30. Does she have a 10?
10 o'clock, 12 o'clock.
So they give people individual times as opposed to we do everybody at one time.
Correct, yeah. So they have a 9 for 30 minutes, 9:30 for 30 minutes, 10 for 2 hours, 12 for 1 hour, and then 2 o'clock for 3 hours.
And that's her rest per day.
That's
I just want to know how much time is set aside for the other motion hearing that Matt has to attend. 30 minutes?
They said 30 minutes, and it could go slightly longer depending on
All
how
right, then we will reconvene here, 1:30 in the afternoon.
We will not.
All right.
I will not be here. That's not what I was told by the judge. That's not what I was told by Judge Aretha Blake. That's not what I was told by Judge Wiggins. And I will comply with the chief judge because you are subordinate to him. And I will be in that hearing and I will comply with the DAs as it relates to that. And then they can address you directly. I will not be here.
Court will reconvene on this matter.
Yeah, I won't be.
1:30 tomorrow afternoon, we begin with the matters and motions to dismiss for subject matter jurisdiction. We are concluded for today. Thank you very much.
Yes, you can
Thank you,
hear a
Your Honor.
motion on mine.
The matter needs to know how we give her a copy of the recording.
Mhm.
And I get where she's coming from. So are they liquid files now, or do we burn CDs because it's live?
No, it goes,
It's electronic?
yeah, email, we can email, yeah.
So why can't we just email her an audio?
That's what I'm doing.
Oh, fantastic, thank you. You have her email?
Yeah.
Ma'am, do you want the clerk to use the email that you use to send her documents to send you the recording?
I don't wish to be taunted. My email is the only email on the record. I'm not going to entertain being taunted.
Go ahead and send the madam the electronic recording today, the email that she sent us.
Will you please? This is my notice of appeal. To the judge.
I'm not,
We filed a notice of appeals in this
Notices of appeal.
No, I cannot submit.
The notices of appeal to the North Carolina Court of Appeals are submitted simultaneously to both the district court and the Court of Appeals. So if the matter has a notice of appeal, she can file it.
I think it should have the, yes. And can I please get a copy of this, Melissa?
A copy of, I'm sorry,
Melissa, may I please have a copy of that?
are you going to clock that in the shifts and, because it's going to reject her file.
That's very interesting that you know that it's going to reject my file. Thank you. And this is all being reported to the FBI on tomorrow.
Okay. Thank you very much.
I'm hopeful that they'll go ahead and proceed with the arrest.
Are you thinking about me now?
Oh, yes, without question. Without question. I've already given your name. Your name is already listed. They're listed by name specifically. Yeah, I'm not a federal ranger for no reason. Yeah, I hope that you are arrested immediately. Of course, I don't make that decision because I'm not in the position of a federal agent presently. If I were, you would already be arrested. But I am definitely reporting this tomorrow and requesting that they move forward.
Thank you. The deputies handle the people before time. We're done for that. Thank you. I'll let y'all handle Jeremy, and you remain on the record. Deputy, I'll let you advise Mr. Johnson and forgiving him for getting the license, co-counsel.
Ms. Reese, Your Honor.
When they can leave.
Yes,
And
ma'am.
you will remain on the record until that.
Yes, ma'am.
I'll let y'all know she's on her letter going down the house.
Thank you.
All together. Just say it.
John, once I get confirmation from both security posts that she has left the building, then the parties can leave.
Thank you, sir.
Yes, ma'am.
Folks on the way home, feel free to do something.
Thank you.
And I'll need that, you know.
We'll be on the security advice.
I'll
Thank
send out
you.
a holiday.
Thank you.
At this point, we can go on the record, everybody, off the record, everybody's in this.